All right, the Supreme Court just handed down a unanimous 9-0 verdict that's going to transform how government officials can engage with you inside your residence. Smash that subscribe button immediately and enable alerts, because you must grasp what this does to your constitutional protections. Disclaimer: I'm not an attorney, and this isn't legal counsel. Firearm statutes shift quickly and vary by zip code. Always consult a licensed lawyer and your local ordinances before acting. The case that changes everything. This morning at 10 a.m. Eastern Time, the Supreme Court issued a ruling that has rocked the legal world. In Case v. Montana, every justice from Clarence Thomas to Ketanji Brown Jackson endorsed one opinion that radically alters when authorities can access your dwelling without judicial authorization. For context, the Supreme Court reaches unanimous outcomes in merely 30% of matters. Regarding Fourth Amendment protections covering searches and seizures, that figure falls below 15%. That every justice concurred signals this transcends ordinary jurisprudence. What renders this particularly consequential is the context. Currently, upwards of 340 comparable matters await resolution in federal and state tribunals throughout the nation, all anticipating this precise determination. Justice Ketanji Brown Jackson authored the majority opinion. What's striking is she formulated terminology acceptable to both the most right-leaning and left-leaning members of the bench. Yet here's what the majority overlooks about this ruling. The tribunal didn't merely resolve one constitutional query. They tackled three distinct legal questions that inferior courts have disputed for years, and one concerns a principle that law enforcement nationwide has exploited as unlimited authorization to access residents at will, the hazardous exemption authorities have been utilizing. For the previous 10 years, police departments throughout the nation have depended upon something termed the community caretaking principle to rationalize warrantless residential entries. This principle was initially developed for an entirely separate objective. It was designed to govern automobiles on public thoroughfares, not private dwellings. Per information from the National Association of Criminal Defense Lawyers, warrantless residential entries, justified by community caretaking assertions, rose 340% between 2015 and 2023. That figure is accurate. We're witnessing an enormous expansion of state authority into your personal domain. Here's how this operated practically. Imagine an acquaintance contacts authorities indicating they haven't encountered you recently and they're concerned. Officers arrive, knock at your entrance, you don't respond because perhaps you're employed elsewhere or visiting relatives, or you simply decline engagement. In Montana specifically, 47 incidents last year followed this precise pattern. In one incident, officers accessed a residence because a relative indicated the occupant was melancholic. They discovered legally possessed weapons and employed a state extreme risk statute to seize them. The Supreme Court just imposed substantial restrictions on this practice. However, their methodology proves more complex than anticipated. What they actually declared regarding community caretaking will astonish you, because they didn't merely restrict it. They entirely dismissed it as justification for residential entry, and that carries enormous consequences. What truly occurred in this matter will disturb you. The controversy reaching the Supreme Court concerns an individual named Trevor Case from Montana, and the circumstances surrounding his experience resemble a terrifying scenario. On the evening in question, Case's former partner contacted authorities near 11 p.m., expressing unease about a telephone conversation they'd had previously. She informed officers that perhaps she detected a firearm sound. Perhaps he mentioned injuring himself. Perhaps he discussed attacking police personnel. She couldn't recall precisely, but she sensed something was amiss. 4 officers responded to Case's residence. Here's a crucial detail emerging during proceedings. All 4 officers personally knew Trevor Case. Upon arrival, they remained 40 minutes outside his property. They knocked. They directed illumination through glass. They announced his name. During this interval, they peered through windows and observed an empty firearm holder on furniture and what seemed to be a notebook. Now, here's where this becomes troubling. Following 40 minutes without reaction, the officers chose to enter via the unsecured front entrance. They ascended to a sleeping chamber, accessed a storage compartment, and located Case inside. One officer asserted he observed a dark item, which might have been anything a mobile device, currency storage, literally anything, and discharged his weapon at Trevor Case. Case endured, yet subsequently faced numerous criminal charges based on a weapon discovered in a clothing receptacle within that chamber. If someone summoned authorities regarding you presently due to their unease, should officers possess authority to access your residence, examine your sleeping quarters, and prosecute you based on their discoveries? The three divergent legal criteria competing prior to this determination. Tribunals throughout America applied three entirely separate criteria to determine when officers could access residences without judicial authorization during urgent circumstances. This generated disorder in the judicial system because what satisfied constitutional requirements in California might violate them in Texas, and what succeeded in New York might fail in Florida. The inconsistency reached such extremes that your constitutional protections effectively varied by jurisdiction. Legal academics have demanded Supreme Court intervention to settle this confusion for years. Criterion 1 was probable cause. This represents the highest threshold, identical to that required for judicial authorization. Approximately 12 jurisdictions applied this criterion for urgent entries. The difficulty: by the time officers accumulate sufficient evidence to satisfy probable cause, the emergency may conclude, and someone might perish. Criterion 2 was reasonable suspicion. This constitutes a reduced threshold. Officers merely require particular facts that would convince a rational individual that something is wrong. Roughly 23 jurisdictions implemented this criterion. Criterion 3 was the community caretaking principle referenced previously. Approximately 15 jurisdictions permitted this, and it represented the lowest threshold of all. But here's what no one anticipated. The Supreme Court selected none of these three criteria. They constructed something wholly novel. And it's a framework that will necessitate complete retraining of officers regarding handling these scenarios. The novel constitutional evaluation every citizen must comprehend. The Supreme Court established what they term the objectively reasonable basis evaluation, and this now serves as the constitutional criterion nationwide. The tribunal determined that officers may access a residence without judicial authorization if they possess an objectively reasonable basis for believing that an occupant is gravely wounded or immediately threatened with such injury. Note those precise terms, gravely wounded and immediately threatened. This phrasing proves essential because it establishes a substantially elevated threshold compared to what numerous jurisdictions applied. This isn't merely "we suspect something might be wrong." It's not "we possess unease." It demands concrete, articulable facts that would convince a rational officer, not the particular officer involved, but any rational officer in those circumstances, to believe someone confronts grave harm presently. Here's where this becomes genuinely intriguing. The tribunal specified particular factors warranting consideration. Did a credible danger report exist? What precisely was reported, and by which party? Did officers observe anything troubling upon arrival? Per legal experts who have already analyzed this opinion, the novel evaluation proves actually more stringent than reasonable suspicion, yet more adaptable than probable cause. It occupies the intermediate position, which precisely matches the Supreme Court's intention. But here's the element that will generate litigation for years ahead. The tribunal didn't precisely define what grave injury constitutes or how immediate is immediate, and that vagueness will generate thousands of legal disputes. Why the tribunal ruled against Trevor Case despite modifying precedent. Here's the development that has constitutional scholars arguing currently. Although the Supreme Court rejected Montana's legal reasoning and determined they applied incorrect criteria, they nevertheless ruled against Trevor Case. The tribunal stated yes, Montana mishandled the legal evaluation, but under the proper evaluation, the objectively reasonable basis evaluation, the officer retained authority to enter Case's residence. This result proves significant because it demonstrates that even under the more stringent criterion the tribunal established, the officer's conduct in this specific matter remained constitutional. The justices identified 5 particular facts supporting entry. First, the former partner's call reporting potential self-injury and threats against officers. Second, the officer's previous knowledge of Case's psychological health background. Third, observation of an empty firearm holder suggesting a weapon existed somewhere within the property. Fourth, the 40 minutes without response, despite repeated contact attempts. The tribunal stated that considering these facts collectively, a rational officer would believe Case might be inside, potentially wounded, potentially suicidal, potentially planning violence. Presently, numerous legal experts already criticize this application. They note that Case bore no obligation to respond to his entrance. The dissent? Actually, no dissent existed because this was unanimous. But here's what's notable. Although all 9 justices concurred regarding the outcome, several authored separate concurring opinions suggesting potential concerns regarding how extensively this criterion might apply going forward. If you're alone at home late evening and don't respond to entrance knocking because you anticipate no visitors, should officers possess authority to access your residence? The 340 pending matters that will now be resolved differently. Recall, I noted upwards of 340 matters pending in tribunals nationwide involving comparable warrantless entry scenarios. Those matters now face complete disruption. Federal public defenders already prepare motions for reconsideration under this novel criterion. State prosecutors scramble to determine which convictions will stand and which will collapse. Here's what will occur during the coming 90 days. Every one of those 340-plus matters will undergo analysis under the objectively reasonable basis evaluation. Matters where officers accessed residences purely through community caretaking. Those will likely be dismissed. Matters where officers possessed solid, articulable facts suggesting immediate grave harm. Those will likely be affirmed. In the Ninth Circuit alone, encompassing California, Arizona, Nevada, Oregon, Washington, Alaska, Hawaii, Idaho, and Montana. 73 pending matters involve warrantless residential entries. State tribunals will experience even greater impact. The National Center for State Courts estimates approximately 2,800 matters currently in state appellate tribunals involve Fourth Amendment challenges to warrantless entries. Defense counsel will file reconsideration motions. Prosecutors must respond, and judges must reanalyze matters they considered resolved. But there's one matter category everyone monitors closely, and it involves a practice growing increasingly common in jurisdictions with extreme risk statutes. And what the Supreme Court declared today could completely transform how those statutes are implemented. The extreme risk statute implications nobody discusses. Here's something absent from the Supreme Court opinion, yet becoming a significant concern. 21 jurisdictions currently maintain extreme risk statutes permitting law enforcement to temporarily seize weapons from individuals judged dangerous to themselves or others. How these statutes function practically often involves officers conducting wellness inspections, accessing residences, then utilizing their observations to petition for weapon removal. Today's ruling just complicated that process considerably because numerous wellness inspection entries may not satisfy the novel, objectively reasonable criteria. Allow me to provide an actual illustration from Colorado. Last year, officers received contact from a family member stating their adult child was despondent following relationship termination. Officers appeared at his apartment. He didn't respond. They entered under community caretaking, observed weapons in plain sight, and initiated an extreme risk petition. The weapons were seized for 12 months. Statistics from Everytown for Gun Safety, which supports extreme risk statutes, indicate 37% of extreme risk petitions originated from police-initiated wellness inspections where officers accessed residences and observed weapons. If a substantial portion of those entries don't satisfy the objectively reasonable basis criterion, those extreme risk petitions could face challenge. Conversely, advocates for domestic violence survivors express concern regarding a separate issue. In numerous domestic violence scenarios, survivors hesitate to permit officers to access their residences, even when endangered. The tribunal's determination creates this tension. It safeguards privacy protections, yet potentially at the expense of intervention in scenarios where intervention proves necessary. During the coming year, we'll observe how this balance manifests in practical scenarios, and it won't be uncomplicated because both perspectives raise legitimate concerns. What this signifies for your protections beginning today. Let's address practical implications. What does this ruling signify for you as an individual citizen beginning immediately? First, if officers appear at your entrance and you decline engagement, you generally need not respond. The mere fact that you don't react to knocking doesn't independently justify entry. This represents an essential safeguard the tribunal has now clarified applies nationwide. Second, if someone requests a wellness inspection regarding you, a neighbor, a former partner, a relative, officers cannot automatically access your residence. They require objective grounds to believe you confront grave harm. Vague unease or concern no longer suffices. Third, and this matters for weapon possessors, the mere existence of weapons in your residence, even visible through glass, doesn't justify warrantless entry. Millions of citizens legally possess weapons, and the tribunal recognized that weapon possession alone doesn't constitute an emergency. However, and this proves the essential qualification if multiple factors coexist, someone reports you're suicidal, officers observe a weapon, you're not responding. Other troubling circumstances exist. Those factors combined might satisfy the objectively reasonable criterion. Fourth, this ruling doesn't affect alternative warrant exemptions. If officers possess probable cause that you committed an offense, they can still obtain judicial authorization. Conclusion: does this ruling achieve appropriate balance between safeguarding your privacy and permitting officers to address genuine emergencies? Or did the tribunal err? So that's the comprehensive analysis of this monumental Supreme Court ruling and what it signifies for your constitutional protections. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.